Take a look at this.
Yeah, I need more money. Show me more money.
What can I show to you?
And you got all this just today?
Just today. Just a few hours. Because I've sacrificed my sleep.
A bag full of cash.
First in history of your passenger.
Wow.
Completing now. Let me ask you a picture. One look.
Well, so there you have it. Like Martin Kpebu. So as the former Deputy Attorney General, now parliamentary candidate for the Timpani constituency on the ticket of the MPP, is saying, okay, let's find ways of criminalizing vote buying. We've seen this video where the person who gave the money, the person who gave the money, its picture and name is on an envelope being shared. You saw it in the video. And the people who were taking the money showing the envelope with the person's name on it, the candidate's name on it. Is it going to be still difficult for the OSP to prove anything?
Absolutely, it's difficult. So, but just a quick one on the public officers standing elections. There have been a number of Supreme Court decisions. There are about at least 3 of them, right, on this matter.
Right.
And so far, the Supreme Court has been clear that, look, the time you say a party has put a candidate up for election is when the party sends its papers to the EC. And that's usually quite close to the elections. So like Prof said, so meaning that right now, if you go and raise it, they will say, oh, he's not standing for elections because the party hasn't put him forward, or if he's an independent candidate, he has not submitted his papers to the EC that he's going to contest the 2024 elections. So considering those decisions that have come to the Supreme Court, I like the way Prof put it, that then we should make a new law. It's as if Prof even knows the state of the law. So the state of the law there, the fact that this is, what do you call it, the Accountant General, Controller and Accountant General is in office, not much. And sometimes that's the way the law is. The law is backward, citizens have moved on, and so we need efforts to reform, to bring the law in tandem with the mores and ethos of the people. Yes, sometimes the law is backward. Other times the law leads the citizens, like the corruption law. The corruption law, you see that the law is leading us, but we are backward. But when it comes to this standing for election, yeah, I see we have moved forward, but the law is backward, saying at the time papers are presented to the EC, that is when somebody is being said to be a
candidate.
Yes, you see. So let's do law reform, okay? That's it. Now, so Mr. Okansi, the matter of the picture, you see, the first technical point we are confronted with is that a party primary, whether for presidential or for parliamentary, is it a public election? That is where the main challenge is. That is where the main challenge is. So perhaps this OSP case will be the test case for the courts to decide. Because you see, when we go to the representation of people's law, even initially, that law was even for only parliamentary elections. Initially, it's raw, the PNEC law 284. Initially, the elections was for parliamentary. Then later, under PNDC law 296, we then amended it to say, and that's what I'm reading, election means any public elections. Any public elections. So question is, when MPP are doing their primaries, Kpebu, I'm not a member of the MPP. Can I go and participate? if you can't participate, can we call that public election? And look, let me state straight away. If we are talking about what is my desire, what is my what do I wish? Oh, I wish the court to interpret to say that party primaries also qualify, because that would be easy. That would be easy.
Qualifies as public elections.
As public elections.
But what is the position of the law now?
Right now, it's not too clear. It says any public elections. And when it says something is public, it must generally be open to the general public. So if it's an NDC primaries and I don't qualify, I can't participate. MPP primaries, I don't qualify, I can't participate. CPP and so on and so forth. So that's the meaning. So it's good. I like it. Let OSP, let it go to court. But right now, we can't tell that it's open and shut. You hear this, so I mean, some of the lawyers have debated this with, we are on platforms, and this has been coming up. You know, this is not the first time this thing is been up. It's been every election cycle it comes up. So you hear lawyers like Samson Ladia and now OSP. OSP, by inviting them, it appears he belongs to that school, who will say that, look, yes, party primaries should qualify HQC Prempe and Co. And sure, if the court will rule like that, we'll all be very happy, because it's easier. Then you hear lawyers on the other side, Ace and Kumenko, who tell that, look, this one is not too clear. So right now, so for them, the best is that let's amend the law. If we get an amendment, to be honest, an amendment would have been the best. But the thing is that in the circumstances, you know, anytime things affect politicians, Honorable, today you are in favor, but I'm not sure it will be that easy in Parliament. Once a lot of your people, some will say it will even relieve them of the burden of paying money. Others who may not be, the ones who came through using money as influence but not their on merit, will not be happy, because they know that, look, hey, if now we are saying we should be by merit, then the person knows inwardly that if it were by merit, he wouldn't be in Parliament. So those people are not likely to support such a law, because they have a lot of money. They buy the seat. You see? So if a court will rule that party primaries also qualifies, good. But if as a people, as a collective, we are all very strong and quickly we are ready, we can pass the law, then it's very clear. So, but right now, going into that case going to court, that will be the first time that the court will decide. But there is a closer case, or let's say there is a case that may lend support to saying that party primaries should qualify as public elections. That is the case of the Republic versus Yebi and Avalifo. That is the case in which 100 million was stolen from this house. And when it went to court, so they raised this matter of jurisdiction, that party matters are not public crimes. Those cases were to be tried, those kind of offenses were to be tried by the public tribunal. Now we've shut them down. But I went to court, Supreme Court, Aqua CJ at the time. They looked at it and they said, things that affect a political party also inure to the general body politic, because the political parties shape the ideas of the state. They do this, they do that, and the way they are central to our political or our democratic dispensation. So finally, and then also the coup de grace, when they looked at it, they say include. And when the word used is include, that means that the definition is not exhaustive. Includes mean more can be added. So in law, that's how come lawyers, as soon as you are defining something, you say people, or let's say people, what's your Bungo, your constituency? They will say, okay, people in Bungo who can vote include 18-year-olds, 20-year-olds, and 21-year-olds. Then full stop.
It's not exhaustive.
Then it means that 22-year-olds can come and say, you only said include. You didn't say means. Yeah. Because you said includes, it means more can be added. So at the end of the day, the Supreme Court held that no, the crimes can be tried by the public tribunal, and most especially things affecting a political party also doesn't affect our general democracy, so they are public. So the word public there. So that is the definition. It means the OSP will be going into this case with the definition of public in Yebi and Avalifo versus the Republic. Let's see how it goes. But so can say, as the OSP is ready to test this case, very eager to test it, I'm wondering why OSP, in the same light, is not interested in testing Adu Boahen's case. Because we have shown that section 252 is what? Influence peddling. OSP himself concluded, they say they have been concluded in his report that
it's
what Charles Adu Boahen did, saying he will go and see the vice president and the vice president cool chop. Baumia will deal with this matter. He says that is influence peddling, but there is no law. And Honorable, we are saying that Section 252 of the Criminal Offences Act talks about influence peddling. So my challenge to the OSP is that if he's interested in this party primaries being a crime under PNDC Law 284, then he should equally be interested in taking Adu Boahen's case to court. Let's test it, because what he's going to do now, he's going to test the law. This party primaries case is doing. He's basically testing the law, because a party primary is not too clear that it is, what do you call it, a public election. Because, right. Honorable, you are not MPP. You can't participate in that election. Even if you are MPP and you are not a delegate, you cannot participate. You see, so it's restricted to some people. Is that a public election?
Okay.
So he is going to test the law on this
this primaries constitutes a public election.
Exactly.
Otherwise.
So if that is so, he should be testing Adu Boahen soon. Otherwise, I'm left with a very bad and deep feeling that it's because Baumia is contesting for elections, he's trying to run away. Yes, because why? Adu Boahen say Baumia will do the thing, cool chop. Baumia can help the sheikh, the investor to, invest in Ghana, and then he, Adu Boahen, will take 20%. You tell us that conversation, everything that happened is what? Influence peddling. But you don't see any law. Meanwhile, there's a law that clearly, if we read, you see that it says A gives or A agrees with B, that B will go and influence C. In that case, it is influence peddling. We see it, and then you say no, you've not seen it. But the other one that is not so clear, that one you say you're going to try. Then be ready to try this. Mr. Counsel, do I have how many minutes more do I have to read?
Or you round up for me?
Yes. Let's look at the influence peddling thing again, because it beggars belief. Look, 252, it says, a person shall not accept or agree or offer to accept valuable consideration under the pretense of having unduly influence or being able or agreeing to influence any other person in respect of functions as a public officer or juror. So the thing is that this one is easier to test. Honorable, why? The Adu Boahen and Baumia case is easier to test because he, OSP, based on the evidence, has concluded that this is influence peddling, but that he can't find the law. And we are saying that this is the law. Many lawyers agree that this is the law.
Let me provide this information to my brother.
Yes.
I think I read his submission.
Yes.
And I did it very carefully. You see, if you read the Office of Special Prosecutors Act, it gives a list of offenses that are supposed to be tried by the Office of Special Prosecutor. It does not include what you are stating.
No, it includes 252.
No,
it's 247 that...
The point is that he looked at the conduct of the person and he came to the conclusion that that will come under the purview of Office of Attorney General.
No. Don't try to defend. You see, politicians. Open the definition. Just open the definition.
I don't know whether you understand. I'm not talking.
No,
I'm not speaking for myself. I'm talking about what.
He's saying no. Honorable, that's not. You haven't read it. Take it easy. Take it easy. He says that it is influence peddling, but that he doesn't find the law. We'll read it.
Because I remember. And that, Martin, and that is the opinion he has on the matter, which you could either agree or disagree.
Right.
Because you are urging him that he should take it to court.
Yes, this one he's going to test.
But he has also stated that it does not fall within his purview.
No, it falls. He's saying that he doesn't see the law.
I think that's the influence peddling specifically.
He admitted that it was influence
peddling. Yes.
But he said, as we speak now, we do not have
any
law fall under any law.
Yes.
And that in other jurisdictions, yes, but in Ghana, as per the laws, that's what he said.
So let's read this.
When you ask you round up.
Yes. Let's read it so that it will be clear. Look, it says 7.1. Though the conduct of Mr. Adu Boahen amounts to trading in influence or influence peddling, which is closely associated with corruption, there is no actual criminal prohibition of his acts in respect of which the OSP has a mandate
Absolutely.
to
That's
what?
what I said.
No, he's saying that there is no
Okay.
prohibition.
That is his opinion.
Thank you.
Yes.
Thank you.
So there is, and he's going
Yes.
to test this one. He's going to test primaries.
You were
So you want him to just get
Yes.
get
He's
into
saying
it
that
and
it
test
doesn't
it.
fall within his purview.
All
And
right.
That is his opinion.
Right.
Until, I mean, we take it to court, and the court makes a definite pronouncement.
Good. So if
He
he's
is come
ready to
this
gamble,
particular interview.
he's ready to gamble on party
so
primaries.
but
Why
your
not?
point is that if he is going into this, then he should also take interest in that.
Yes,
as
Adu
well.
Boahen's case.
Thank
Because
you.
Adu Boahen's case will
Right.
never die. Mr.
Well,
Jabe, this case will never die. We go tango, sir.
Professor Jampo, let me bring you on
let's
this
move our
point.
democracy
I think
forward.
that from you, from your political lenses perspective.
No, Adu Boahen.
So
Adu Boahen,
I've got some confirmation for you.
Number one matter.
That's what Adu Boahen says he's going Gentlemen, please. Thank you. So, yes, Edward Bauer, what you made mention of, this is Achim Swedru constituency.
Yeah.
That's where Kwesi Kwening Bosompim, that's the name, is nursing the ambition to contest. He's going against Kennedy Osenyako, the chairman of the Roads and Transport Committee of Parliament. Correct?
Yeah.
Okay. Professor Jampo, this phenomenon, it's not new, and it keeps coming out. At least the only new twist to this, reason why we're having this conversation, is the OSP even wanting to get into it so as to help the likes of Joseph Benka, who want this to be criminalized as well, despite the hurdles they say he will face.
You see, today I came here to talk about lithium. I
Yes.
didn't come to talk about all
So
these
you
things.
round up on this one, we'll get into the
These things, they've been one too many. And I think that the earlier we do something about them, the better. We've been talking about them virtually every time elections are held. We've been talking about them. And this OSP thing, I think the OSP has too many work in progress. He would go and touch this and leave it there, go and touch that and leave it there, and popularize it and leave it, pussyfooting things and just leaving them. He has too many work in progress all over the place. It doesn't show seriousness. And Martin, I thought I told you that I wanted to sue him, and then you were going to be my lawyer. What has happened to that?
Yes,
on this particular, on the other
research
issue?
is still ongoing.
Yes. I
research is
think
ongoing.
we
We'll
must
go.
take him to court and ensure that he does what he is required to be
We're going
doing.
to take the OSP to
Yes, I mean, I don't. He's just, and then you go and just do emotional blackmail, saying you are Nkwanoma and that one. What is that? You focus on his work
Tell my
and.
brother that he exercised it under Article 296. It's a discretionary power he has as a special prosecutor, and in his judgment, he thinks that this is the law.
But there are
So you could go to court and the court says otherwise. He has exercised the
gentlemen,
discretion.
thank you for the intervention.
And we
Let
have
Professor Jampo
No, let
round
them
up.
intervene.
Yes.
I have nothing more serious to say beyond what Martin has said. I said I came here to talk about lithium.
Indeed.
The lithium thievery. That's what I want to talk about. I'm not interested in this. Let the OSP focus and deal with one issue at a time. Carry that issue to its logical conclusion. What has happened to the Sisiadapa matter? You see, you bring matters to the public domain and then we talk about it, and he's pandering to the typical Ghanaian attitude and culture where we know that, we do not celebrate the 1 week of every matter in Ghana. Every matter that happens in Ghana, you talk about it in 2 days, 3 days. It doesn't get to 1 week, and then we are done talking about it. Because of some of these things, there are too many work in progress. OSP is doing this, then he hears this quickly. He wants to be here doing something about it. Then there is somebody chasing a file, going to steal a file. Quickly he wants to be heard chasing it. Somebody going to steal a goat. Quickly he wants to be heard talking about. That is not how to fight corruption. You don't fight corruption by pussyfooting it. What you do is to make sure that if you are handling one particular matter, handle it with tact, with seriousness, with focus, and ensure that there is finality. I don't know the case that OSP has ever finished handling. Every day and every now and then, the OSP is doing something and it will not finish. The OSP, have you forgotten? I think there was an election that somebody was sharing bicycle or something, and then another election that somebody came out to say that he is demanding he bribed some people. They didn't vote for him.
He's on trial.
And
they called a number of witnesses.
So trial in perpetuity. We don't. He doesn't finish anything. He's always doing work in progress. And you see, the fight against corruption is not muff. It's not about talking and being heard. You, Martin Kpebu, and the other time, when we're talking about this man, you felt that we're doing something too much. And then you have some lawyers like Sanson and they will text you and say, well, do you have something personal against the OSP? OSP, he was my mate. We're all in the Kwafu hall. I don't have anything personal against him. Okay, what we are seeking is Ghana. So that Ghana will work. And if you're a young man and given that kind of fiduciary trust to perform, because you have the zeal, you have the energy, and you have the intellect, we expect more from you.
Okay.
It's not about pussyfooting problems and always having work in progress. If you hear somebody going to steal a goat, then you are chasing and you make it public. You hear somebody going to steal...
but Prof, that helps.
So always chasing, and no, I'm saying that, but let an issue be addressed and let there be finality. He has too many work in progress.
He doesn't have control over the court, like the NDA one. This is the one that
he doesn't have control over the court. You see, when he was appointed, the way and manner he spoke suggested to some of us that he was going to perform some magical wand to bring even the judicial arm of government under his control. Didn't you know? Wasn't he a lawyer before he was appointed? Didn't he know that if you go to court, there are processes that you have to, be resorting to, and then sometimes it drags, sometimes it delays. And today he's out there in his capacity as a senior lawyer now, speaking against the court. Didn't he know?
I disagree with you.
Didn't he know that the court
with any judgment of the lower court? You go on appeal.
Was he not aware that the court...
Okay, thank you.
He created an impression that he was a messiah.
That
he was the conscience of the nation. If you are conscious of the nation, how do you describe the one who appointed the
Okay, thank you. Mr. Penka, just round up on me on this one.
I was just, he mentioned something, and I was just coming to that about the Office of Special Prosecutor. I think that some of the utterances by him are needless. And he has to be very cautious, because that's a very big office that was created for a purpose. You see, you as lawyers, and Martin knows very well, that you go to court with evidence, and then the court takes a decision on the basis of the evidence and the law. Now, if you are not satisfied with any decision of any court, your other option is to go on appeal. If it is a high court, you go to the Court of Appeal. If you are not satisfied, you go to the Supreme Court, and then finality is brought on the issue. But when we begin to run commentary, as if you go with any case to court, you must necessarily secure victory. And if you don't secure victory, it means that there's a conspiracy and a gang up against you. That would be most unfortunate, because the courts are there to make pronouncements on the law. And that is why if one judge errs, you go for a 3-member panel at the Court of Appeal.
Not to come and say you are
but to come publicly.
And then you come and say,
that one is completely needless. It amounts to denigrating the courts.
Okay.
And that one in itself can be
a singing
and talking about
that one is getting wrong. And he's seeking to court public sympathy.
It's unnecessary.
No. It's absolutely needless.
Thank you.
And I think that the earlier that was taught, the better.
And this is coming from
And if the law is against us at the lower court, and we think that we are going to appeal and go to the Court of Appeal.
Many of you people in the NDP, you are not seeing
But if we begin to run commentary, and then you come to the public and you want to tell the public that you are Mr. Angel, but the rest of the people are devils, and they are those who are thwarting your efforts, courting public sympathy and all that. That's a cry too loud that no one will have sympathy with you.
Do you know that currently in the Supreme Court now, actually a citizen is in the Supreme Court even challenging the legality of the office of the special prosecutor.
And this is a case that is running. So
yes.
We'll see how things play out. Thank you. And this coming from the former Deputy Attorney General, instructive indeed. But this